So welcome to today's webinar. I'll just start off with an acknowledgement of country. Legal Aid Queensland acknowledges and respects the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. So thank you for joining us this afternoon. Our webinar is on domestic and family violence pathways to safety. Our presenters are Lindy, a senior lawyer and FDRP in the Violence Prevention and Women's Advocacy team, Marie, our Pathways Officer in PCC, and Kelsey, a domestic and family violence practitioner in the Child and Family Services team. So just a little bit of housekeeping before I hand it over to our presenters. My name is Kiara. I'm a Community and Legal Education Officer here at Legal Aid Queensland. Today's webinar is being recorded. The laws and content is accurate on the day of the live presentation and may change. Any information you can access on our Community Legal Education page, and for any technical support, please contact the GoToWebinar customer support team. Today's webinar will be approximately 40 minutes of presentation with 20 minutes of questions at the end. We have had a lot of questions come in, so we'll try to, most of them will try to be addressed during the presentation. We'll ask a couple at the end, and if we run out of time, you can just email them through to the CLE inbox. I'll forward them on to the presenters, and if they're able to respond, they will. The question box can just be found in the bottom, so you can type in any questions there. And you can also access today's handout in the download handout section. And I'll also be sending a copy of the presentation in our wrap-up email next week. So just a really quick poll. We just have 2 to get you started. So the first poll is, which region do you work in? Southeast Queensland, Far North Queensland, Regional Queensland, and outside of Queensland. And I'll just give a few seconds for that response. Wonderful. I might close that. I'll close that out and just share. So we have 57% from Southeast Queensland, 16% from Far Queensland, and 27% from regional. So no outside of Queensland today, which I think would be relevant for the presentation. And just one last poll. So what is your role? Support worker, financial counsellor or health education worker, social worker, lawyer or other? We're getting a lot of responses, so thank you everyone for that. I'll give it a few more seconds. Excellent, I might close that one off now. Okay, so today it's 19% support worker, 9% financial counsellor or health education worker, 18% social worker, 26% lawyers and 28% other. So hopefully that will help just frame who the audience is today. All right, wonderful. So I'll now hand it over to our presenters.
Thanks, Kiara. I'll kick off. It's good to see we've got a sprinkling of different disciplines there attending today. Hopefully this information will be relevant and helpful to all of you. So we'll be talking about legal advice services, how to access domestic and family violence help, duty lawyers, court assistance workers, and I acknowledge the outdated terminology there. Kelsey will correct that in her presentation. Our application assist program, applying for legal aid, and then our referral pathway program, which is a special program to assist more vulnerable clients accessing our services. So you might be wondering why we're here today. So it's really commemorating Domestic Violence Prevention Month, and this is one of the activities that Legal Aid Queensland is involved in, is the presentation of this webinar. And you'll see the theme for this year is about taking positive action today to build a safer Queensland. So it's really about not being a bystander, not leaving it to others to fix the problems, and taking responsibility. It's not just perpetrators, it's really a problem that touches all of us. The next slide really, again, is about context, about why we're here. So there's only, the graphic there represents one of the reports in this process, really, of responding to the domestic violence issues in Queensland. It all started with the Not Now, Not Ever report back in 2015. Then there was the Hear Her Voice report that made a number of recommendations for improvement, and that was it. In 21, 22, there was a further report, and then we've had the Commission of Inquiry in November of 22, and it's good now to be able to reflect on all of that and see that so many of those recommendations have been addressed, that things are improving. There's still a lot of work to do, of course, but things are improving, and we can see, just as a snapshot, the number of police applications have improved dramatically compared to back in 2015 when I became involved in the specialist court project. So moving on, Kelsey, thanks.
So domestic and family violence includes a wide range of behaviours that control or dominate someone or cause them fear for their personal safety or well-being. These behaviours may include physical abuse, sexual violence, emotional and psychological abuse, threatening behaviour, and coercive control. Evidence-based risk factors are circumstances or behaviours that, where present, indicate a person may be experiencing or using domestic and family violence. They've been identified based on current and empirical research into domestic and family violence. Some of these risk factors or red flags include strangulation, threats to harm, escalation, abuse during pregnancy, and sexual violence. Domestic and family violence, we know, is widespread. It impacts people of all ages, genders, cultures, and socioeconomic backgrounds. Researchers have determined that in examining a way in which gender relations are structured is key to understanding violence against women. Many studies locate the underlying cause or necessary conditions for violence against women in the social context of gender inequality. While there is no single cause of violence against women and the relationship between gender and violence is complex, it is now widely recognised that gender inequality is a key driver of domestic violence, often in intersection with other social inequalities such as age, race, disability, and social class. This concept is reflected within the current statistics relating to domestic and family violence. Go back a little bit, sorry, and back again. Thank you, sorry. According to the 2021-2022 Personal Safety Survey, 1 in 4 women and 1 in 14 men have experienced violence from an intimate partner since the age of 15. For people who do experience intimate partner violence, 77% experience it by a male partner. Similar prevalence is also depicted in the number of intimate partner homicide cases between 2010 and 2018, where 77.2% of these homicides were committed by male perpetrators. Domestic and family violence is considered a national crisis with significant implications across social, health, economic, and legal domains. For example, in 2022-2023, 1 in 3 hospitalisations of assault were due to domestic and family violence. Of these hospitalisations, 74% were for females and 26% were for males, and 63% had the perpetrator reported as a spouse or domestic partner. In regard to our legal system, almost half, so 47% of civil cases in the Magistrates Court in 2022 and 2023 involved a domestic violence order. And in the family courts, experiences of family violence were alleged in over 83% of applications for parenting and/or property orders in 2022-2023. And finally, in 2015-2016, it was estimated that violence against women and children cost Australia an estimated $22 billion, taking into consideration the cost of the health system, counselling and other related services, the justice system, child and welfare support, as well as lost wages, productivity and potential earnings. While domestic and family violence can affect anyone, there are particular groups of people who are more vulnerable and susceptible to experiencing abuse. These groups include First Nations people, the LGBTQIA+ community, culturally and linguistically diverse communities, people with disabilities, children and young people, older people, women and young people in regional, rural and remote communities, and women living in areas that have been recently affected by a disaster. So this presentation is about how legal aid can help those experiencing violence navigate their safety, and there will be discussions about the legal avenues in order to do so. However, it is also important to note that pathways to safety can differ, and the steps one person takes to reach safety can actually heighten the risk for another person. There is a common assumption that a person experiencing violence has the power to stop the abuse if they just leave the relationship, which is not the case, as we also know that abuse can escalate pending and post-separation. People experiencing violence may actually determine that it is safer for them to remain in the relationship. And those who are experiencing intimate partner violence and are still within the relationship face several barriers to separating from their partner. These can include hope that the abuse will end, isolation from support, dependency on their partner, fear of escalation, risk of homelessness, experiences of embarrassment or shame, fear for the safety and custody of their children, and previous system failure. Where leaving the relationship or obtaining a protection order is not safe for the person experiencing violence, there are alternative pathways that can be considered in the interim, such as referring them onto a specialist DV service who can collaborate with the person to formulate a safety plan. There will be slides later in the presentation that list a number of these services. When working with these clients, it is important that we collaborate with them and treat them as the expert in determining what is and what is not safe for them to do so, and to ensure that we are providing the appropriate service.
And that collaboration is actually one of the best practice principles that comes within this framework. So back in 2020, Legal Aid Queensland and the Queensland Law Society worked together to develop this document or this framework to provide a bit of a blueprint for the best practice for legal and non-legal workers within this area of specialty. So the first best practice principle, and I should say also that this is a really helpful tool for people working in the sector, because it not only provides these principles, but it also provides some really useful practice points. So even though it may seem very straightforward and common sense, it's a really useful document and standard for work in this area. So the first one there about improving your understanding, really important to keep up to date within your area of practice, attend conferences, webinars like this one today, reading articles, and really keeping up to date with changes. For example, the introduction of the coercive control laws, that's changed fairly dramatically over recent times, this year in fact, and it's important to stay on top of those changes. Number two, prioritising not only the safety of the clients you're working with, but also your own safety, being aware of the environment that you're working with, security services that are available, protecting the identity of clients, ensuring that your colleagues know where you are when you're at work, if you're at court, if you're leaving court, for example. Number three, empowerment is very important. So this is about providing a safe and trusting environment for clients, adopting a trauma-informed practice, and respecting that clients may make choices that are different from the choices you may make if faced with similar dilemmas. So it's about being respectful and recognising that trauma can impact on the behaviour of clients. So again, giving time and really adopting that trauma-informed approach. Fourthly, ensuring that people using violence are actually held accountable, promoting accountability. There is provision for that in the legislation, of course, but it's important that we as service providers don't collude with a narrative that, for example, blames the victim for her predicament or provides the perpetrator or the person using violence with an excuse. Call the behaviours what they are. Number 5 is about communicating respectfully, which flows on appropriately and reflective and respectfully, I beg your pardon, flows on from facilitating empowerment for our clients. Ensure that we demonstrate understanding, congratulate clients for stepping forward. We know from the studies that it will take a victim 7 attempts to reach safety. So it's very important how we present to them in a non-judgmental, encouraging, unbiased way. Remember that one size doesn't fit all, so be respectful about cultural diversity and demonstrate that we have an understanding of the issues involved for our clients. Again, it's not about excusing behaviours, but understanding behaviours in a non-judgmental way. And finally, collaborating, as Kelsey said, with other services to, again, it goes with that trauma-informed approach, that we are not exposing our clients to having to retell and re-traumatise them by collaborating with other services. So the next slide summarises the pathways through legal aid, some of the pathways that are available. Firstly is our call centre, and that will get through to directly to legal aid. Secondly, that's the team that I work with, that's our direct number. Thirdly, there's a link that you'll get when you receive the slide from today's presentation. That links you through with the duty lawyer services, and we'll go through this in more detail. Fourthly is Kelsey's team in terms of the social supports around domestic violence services, and fifthly, applying for a grant of aid. And these all relate to clients that are able to directly access our services. Marie will talk about the pathways for clients that are more vulnerable, who can't directly access these services themselves. So number 1 is contacting our call centre. And this option would suit, as I said, clients who are able to self-refer, who may have multiple legal issues, who are unsure of the legal area in which they need assistance, or they're requiring general advice and information on the next steps they should take. Next, if they're fairly sure it's a domestic violence matter that they're requiring assistance with, they can contact our team directly. And the contact person will triage that matter, because it may be that that there are other services that they require as well. But if it's domestic violence matter primarily, then they'll do an intake process, and then that client will be listed for phone advice. Again, this is for clients who can self-refer, who are able to do that, and where the main presenting problem or issue that they're requiring assistance with is family and domestic violence. The third service is domestic and family violence duty lawyer at the court. So this service provides legal advice and representation in the specialist court model on the day of the mention. So the day on the court documents, the date that you're required to go to court, that's when the service will be provided. The level of assistance does vary from whether it's a specialist model court or an enhanced model court, but generally we provide advice, advocacy, representation in court, again on the day. We cannot provide advice about matters that are not listed that day. So there are other services that we've talked about that are available where you're wanting general advice. For example, you ring for advice through to our team. No referral is required. You just turn up at court on the day, and the client should bring with them their paperwork. And we really can't stress that enough. It's very difficult when clients turn up at court with no paperwork. It makes it very difficult to provide that advice service. So the main target of this service is for people who've not had legal advice or assistance with their matter previously. Court support, I might just leave that for you to talk to in due course. Do you want to talk to that slide now?
I can talk to it now, that's fine.
Yep, it's got your name.
So Legal Aid Queensland provides domestic and family violence non-legal support, predominantly for people experiencing violence. So for example, we have the Application Assistance Program, which is facilitated by the Legal Aid Court Assistance Service and operates as a drop-in service on Fridays at the Brisbane Magistrates Court from 9 AM to 1 PM. Appointments, if there is capacity, can be made with clients at Brisbane Magistrates Court or at the Legal Aid Herschel Street office as appropriate. Support outside of the drop-in hours can be offered if the application is assessed as urgent and the team has capacity to provide that assistance. So the sort of support that can be provided at the Application Assistance Program can include clients who are wanting to apply for a protection order, clients who are wanting to apply for a variation of a current protection order, and we can also assist with things like legal aid application forms as well. It is a bit of a wraparound as well, so we can also assist clients with safety planning and referrals to other services as well. There are other regional domestic violence services that may be able to provide similar support to their clients who are in other areas other than Brisbane Magistrates Court. Alternatively, people who are experiencing violence may contact Legal Aid Queensland or Community Legal Service for assistance with applications. Our number's also on the screen there, so that number can be contacted by services, clients, everybody. So next we have our domestic violence court support service. So along with the duty lawyers on the day of court, there are court support workers who are available to assist clients with safety management planning and to help them understand the court processes. So for example, in the Brisbane Magistrates Court, support workers from my team, so the Legal Aid Court Assistance Service team, can assist clients with accessing the court safety facilities, explaining what a DVO is, its conditions and what to do if an order is breached, explaining their options and the court process, advocacy and liaison with court security, the registry, duty lawyers and other stakeholders, giving support and information in court and throughout the court process, safety planning, emotional support, and we can also make referrals to other services. Thirdly, there is other court support that we can provide. So we know that domestic and family violence presents a majority of family court matters. Legal Aid Queensland's Family Advocacy and Support Service provides legal and social support to individuals experiencing domestic and family violence who also have a family law issue. our social support workers can provide support and advocacy to these individuals in regards to safety planning, emotional support, referrals, protection order application, assistance, system navigation, and in-court support. So for clients who would have family court matters in the Brisbane Family Court, you can also contact our team on the number that's on the screen. For other family courts within Queensland, it would be best to likely contact the Legal Aid General number first. But we do provide that in-court support for the family court matters, which is can be of great assistance to people who are feeling really overwhelmed and nervous about the process. We can that is part of what we can do.
So the next level of support, if you like, is applying for a grant of legal aid. So the difference here is that if you're eligible and your application is approved, you're getting a solicitor appointed for your individual case. So this is about cases that have an ongoing aspect. So you need to apply formally by application, and then it's assessed and a decision is made and you're advised of that. The types of services that are provided are generally representation, and that includes those items set out on the slide there. Next, we'll look at domestic and family violence, the duty lawyer service. And you heard me speak earlier about the differences between the specialist and the enhanced model of courts. So this whole process really began, as I said, as a result of the Not Now, Not Ever Quentin Bryce report back in 2015. I was fortunate enough to have been involved in the initial training for the specialist court in Southport back in 2015. And it's really, the process has gone, or the program, from strength to strength. And you can see the number of specialist courts there now. And the enhanced model, really not that different. It just means that we may not represent all presenting clients at court on that day, but we certainly endeavoured to do that. And I speak on behalf of all my duty lawyer colleagues when I make that commitment. So what does the role involve? Again, we are taking steps to ensure that clients understand the process. We know it can be very daunting when you've not had a matter before the court before. So we'll explain the outcomes, the likely outcomes to expect, not only for the aggrieved, but what the respondent might expect. Not that we are representing both clients. There are respondent duty lawyers as well as aggrieved duty lawyers available on the day. We will seek, or endeavour to seek, appropriate conditions. We'll negotiate with the other party, with the prosecutor on the day. We will certainly advocate to ensure that clients are protected by temporary orders if that's appropriate. And that's one of the amendments actually that came into effect on Monday, provides for the magistrates now, they must consider the making of a temporary order, which is a good thing. As I said, we'll negotiate with the other stakeholders, we'll appear in court on the day, and we'll make appropriate referrals and ensure that the client has assistance with the legal aid application form if they're likely to be eligible. So obtaining a grant of legal aid, as I said, requires the completion of the application form and basically attaching all the relevant documents to that form. So you'll need proof of income, proof of assets. There are strict means tests that are applied, just as there are merit tests applied. So you'll need to attach court documents, an application that's been filed in the court, a copy of any temporary orders that have been made, and details of the next in court date is really important so that we're ready to respond if the grant of aid is made. As I said, there is a means test that is applied by Legal Aid, and there are some exceptions there to keep in mind. If your client's a child, there's no means or merit test applied there. So if you're in a situation where a child is the respondent or the aggrieved in a domestic violence matter and you have concerns about that, then don't hesitate to get in touch with us. That child can be legally represented when the matter is next before the court. There's also a merit test, and that involves the reasonableness, really, of what you're hoping to achieve. So if you have a matter where there is no likelihood of success, then you're unlikely to be eligible for legal aid. And that stems from the ultimate test that we are spending public money. So that needs to be strictly applied. Our grants team make all of those decisions. So for myself as a practitioner in one of the legal teams at Legal Aid, we appear or we represent clients only when they receive that grant of legal aid, just like our preferred suppliers in private firms who undertake legal aid. They must obtain a legal aid grant as well before they're able to undertake that work. It's important to let us know what the legal problem pertains to, provide some detail. One shortcut around this aspect of the application, in addition to including the relevant paperwork, is to refer the client for legal advice by one of our in-house legal practitioners, because in that regard, we are able to e-lodge the form electronically in-house, and that may provide your client with a shortcut to a decision in relation to their application. Because if the matter is meritorious, we can certify that there is a likelihood that the merit test will be met. So then once the grant of aid is approved, it's allocated to a lawyer or in-house or externally, as I said, to one of our preferred suppliers. And the client has obligations then as well. They must keep us advised as to their contact details so we can contact them to obtain instructions and keep them up to date with their matter. And they must provide timely instructions, and they also must comply with directions and advice from their lawyer. And there are times, of course, where that doesn't go smoothly and grants of aid are unfortunately terminated or redirected, but that is one of the obligations of that grant of aid. Important also to understand that legal aid is not necessarily free to all. If there are property settlement matters, for example, it may be the case that legal aid will issue a retrospective contribution from the client to assist in the payment of some or all of their legal fees. But the legal fees will always be significantly less, of course, than they are through the private sector, as you would expect. There's a list there of some key resources in relation to domestic violence matters, which I strongly recommend for clients and also practitioners, for that matter, who are assisting clients in the completion of a legal aid application, a domestic violence application for an order. That booklet is particularly useful. It sets out a template for an affidavit for the application itself, lots of really useful information there, and the best practice framework that we spoke about earlier on. And handing over to Marie to take us through the Pathways program.
Thank you, Lindy. Good afternoon, everyone. My name is Marie. I am the Referral Pathways Officer here at Legal Aid Queensland. So today I will run you through, what the Referral Pathways program looks like and how you guys can utilise that pathway. So essentially what the Referral Pathways is designed for is to provide a warm referral from an agency to Legal Aid Queensland on behalf of a vulnerable client. So we want to reduce those barriers in seeking legal advice for these clients. I will, generally speaking, in order to be eligible, we do have a criteria for these vulnerable clients. I do go in more depth when I do the training sessions with agencies for them to become registered, have a registered partnership with us. So our main aim, as I said, is to provide priority legal advice within 1 to 2 business days for these clients. I'll go into the eligibility criteria shortly. Whilst we have an RPP, it's commonly known as at LAQ, we do have an RPP in most of our regions. Not in Mount Isa, Cairns, Rockhampton or Inala. In saying that, talks have begun with Mount Isa and Cairns, so hoping to establish an RPP in those areas very soon. So the RPP, just a bit of a background, the RPP came about as a result of the 2008 Violence Against Women strategy that found occasionally clients, particularly those experienced domestic and family violence, were facing a lot of barriers with self-referring for legal support. So in response to this, we wanted to reduce those barriers to ensure that these vulnerable clients weren't in fact falling through the cracks. We can now offer those vulnerable clients priority legal advice from identified service partners via a supported referral. So since the program began, we've received more than 4,000 referrals and currently have over 160 registered agency partners throughout the state. Now, you're not going to find any information regarding the Referral Pathway program on our public-facing website, and that's simply because we want to ensure that the referrals that we're receiving are relevant, that they're within scope and are in fact appropriate for the RPP. So some of the benefits to note in relation to the RPP. So as mentioned, our aim is to provide legal advice to your client within 1 to 2 business days. We're trying to reduce those barriers, as I said. We're trying to engage these clients who don't have the capacity to self-advocate themselves. Within the process of the training and so forth, I would provide the newly registered agency with a copy of our referral form. So by capturing critical information on that referral form, we're intending to avoid re-traumatising these vulnerable clients by having to retell their story over and over. The lawyer will likely have some clarifying questions when that advice is being provided. That'll be in relation specifically to their individual situation, but at the least they're going to have that, a relatively good idea about what's going on for that client. So they're, as I said, not having to retell the story. So client eligibility. So in order for a client to be eligible to be referred through the RPP, they firstly must be deemed vulnerable, which is the responsibility of the agency. When I do the training, I run through all of the options. Sorry, probably not options. All of the aspects that can be deemed as what deems a vulnerable person. So they must prevent with at least one vulnerability. More times than not, they're going to have more than one, but there must be that one. So basically, essentially clients being referred through the RPP, as I said, are typically not the type of client where you're going to be able to say to them, here's the Legal Aid call centre number, go and give them a call and book in for a legal advice. They're highly likely they're just going to take that number and, nothing will happen from that point. So, these people may be facing barriers such as trauma, even fatigue with the system, and they just don't have that capacity to self-advocate. So that's where this warm referral from the agency comes in. Important to note that one of the other eligibility criteria is that the type of advice that the client is seeking is in relation to domestic and family violence, family law, and or child protection. Again, the client must lack the capacity to contact us themselves. I do like to mention, if many people can be vulnerable, but they still may have the capacity to self-advocate. If your client is one of these people, then they should not be referred through the referral pathway program. We want to empower these vulnerable clients, if they can, to reach out themselves and seek that advice themselves. So following the training that I would provide to an agency, obviously I would go a lot more in depth in relation to client eligibility, but in a nutshell, there are certainly criteria there that needs to be followed. So for those clients who are not eligible to be referred through the RPP, they obviously can self-advocate for advice by calling our 1300 number. They can also, as Lindy discussed, they can simply apply for a grant of aid to potentially become represented, obviously by completing a legal aid application form. Your clients can obviously, regardless of where, you don't have to be in Brisbane. We've got our offices all throughout Queensland. So your client can actually contact their local LAQ office and ask to be booked in for an advice session that way. It doesn't have to be through our 1300 number. For those clients with child protection concerns that are before court proceedings have commenced, the agency can actually refer them to our child protection early legal service. The email you can see on the screen there. Keep in mind that only an agency can refer the clients for this service. Clients can't actually self-refer in relation to that assistance. Just a bit of an FYI, I suppose. As I mentioned earlier, we've got RPPs across most of our regions. This little map here just shows where all of our legal aid regional offices sit. And as I said, with the exception of Mount Isa, Rockhampton, Inala and Cairns at this particular stage, all of these other regional offices do have an RPP in place. So if you're an agency in any part of Queensland, you can either contact me, which is probably preferable if you're interested in becoming an agency partner or just learning more about the RPP, or you can contact your local legal aid office yourselves. So as I said, if you are interested in discussing the RPP further, or if you think this pathway would benefit your clients, please reach out. My email address is there, my contact number is there. I do a lot of face-to-face trainings as well as trainings via Microsoft Teams, which obviously is handy when you've got people, agencies in Cairns or further away from me that I can't attend. Our trainings usually take approximately 1 hour. If you're local to the Brisbane area, I do generally prefer to come and do a face-to-face session. It's just a little bit more personable. So in terms of becoming a registered agency, excuse me, the process of how you guys are going to refer clients in is quite formal. We follow a certain process, which I go through in the training, but the partnership itself is quite informal. It's quite literally, I would arrange a time to do the training with your agency. and all of those relevant people that potentially will be referring clients in. After that training session has been completed, I will simply send an email through to you guys to say, you know, you've done the training, hey, would you like to become a registered partner? And it's simply just, yeah, we would. So it's really quite informal. You would then reply to that email saying, yes, we'd like to become an agency partner. And then from that point, I would send you all of the resources, including the referring forms, and then you can start referring clients. So that in a nutshell is a kind of a, you know, a very basic rundown of what the referrals pathway program looks like and who it's designed to help. Very important to remember that there is that criteria, eligibility criteria, and it's for a very good reason, because it's designed to, you know, protect and make sure that these vulnerable people aren't falling through the cracks. So I've just included here some other phone numbers that may be beneficial to you guys. These numbers can also be found on the website if you choose to have a look at our website. The first number at the top, the 1300 65 1188, that is our general call centre number, which has been noted throughout today's session, and that is open to whether it's an agency or a client. Everybody can contact through that number. Important to note, excuse me, that our Indigenous hotline is a priority phone line, which is available for Aboriginal and Torres Strait Islander people who require legal help. Some takeaway tips. So whilst I've mainly spoken about the RPP program, which I am extremely passionate about, there are many other resources available through LAQ to assist your clients or your agencies as well. Some of which you've heard today, but yeah, there's, and I will just mention again, if you are interested in learning more about the referral pathway program, or you're interested in becoming a registered partner, my email address again is there. Please reach out. Probably better to email me as opposed to call my phone, because I am very, very much away from my desk doing trainings, etc. For a fair bit of the time. So thank you very much. I appreciate your time today. And I will pass it over to Kiara.
Wonderful, thank you so much. That was an amazing presentation. So we have had quite a few questions submitted prior to the webinar. Whatever wasn't addressed, we'll just ask a couple now, and then anything else I'll refer back on to our presenters, and if they are able to assist, they can respond. Please note if there's anything about general or very specific legal advice for a client or a case, our presenters cannot answer that, and you will need to contact one of the numbers that have been discussed today. So one of the pre-submitted ones I'll just quickly ask, does the client need to have legal representation if police have filed a protection notice but the partner is also filing a DVO?
So I'll take that one, Kiara.
Thank you.
That's what we would call a cross application, and the short answer to that is yes. Sometimes the magistrate may make a recommendation to the police prosecutor that they ought to assist the client in relation to the cross application, but that doesn't always happen. You can't assume that that would happen, even though it makes sense if you're there about the primary application, that the police would assist you with the secondary application or the cross application. Also, there are fairly new rules about how the court deals with cross applications, and the magistrate needs to make a finding about who the person most in need of protection is. And that will often have the impact of, or the result of, only one order being made. But still, you may need representation in relation to that argument. So, short answer, yes.
Thank you. So we've had a couple of questions I might just refer straight on to the teams. I don't know if they're directly relevant today, so I'll get you to have a look first. One that came in, is the DVCAS program only available to parties when matters are in the Brisbane Magistrates Court?
Sounds like it might be referring to the court assistance.
I think so, yeah.
Yeah, so this particular service is for the Brisbane Magistrates Court. There are other specialist DV services that provide similar support in other courts. One of my recommendations, I think that in one of the last slides, there was a few links for some sort of service directories. So you can use those directories to have a look at what sort of specialist DV services are available in the local areas, and then contact those services to inquire about who provides what service and where. Would be a good place to start. But it's a valuable service, and there are similar services for different courthouses.
Wonderful, thank you. Another came in, so apologies if it's relevant. It said, if the client said they didn't want to proceed with applying for a DVO, what could you do to support them?
Both might comment on that. So legally, if they don't want to apply for an order, they don't have to. They could, if it's a private application, they can withdraw their application. But I'm guessing that the inquiry is really about a situation where police have made an application for a protection order and the aggrieved protected by the order is not really supportive of the order when it comes before the court. So that is a little bit more nuanced because the court has to prioritise the safety of the aggrieved. So in that situation, the law provides for the wishes of the aggrieved to be considered, and certain magistrates give those wishes greater priority than others. And as part of the role of the duty lawyer is to be the advocate for the wishes of the aggrieved. They may require fewer conditions, more conditions, different conditions, or as the caller has identified, not be supportive of the order at all. But ultimately it's a matter for the court. As to supporting the client through that process, Kelsey?
Yeah, so there's other things that we can do if the client doesn't want to go down the avenue of applying for a protection order. And those things include doing some safety planning with them, so looking at what other sort of safety measures that can be put in place to assist them if they don't want to go down that more legal avenue. So that could include things like looking at their home security, linking them in with services or supports who can assist with installing security cameras or changing locks, looking at their support network and seeing what else could they benefit from if we're looking at intersecting needs such as mental health, drug and alcohol support, really trying to work with the client and collaborate with them to determine what they need at this point in time. And also, I think part of that, and Lindy mentioned it a lot before, is respecting their decisions and their wants in terms of what they feel that they need at this point of time, and providing them guidance in regards to that. So I think it's important for us that we're not judgmental and we're really listening to them in terms of what they are needing.
Thank you. So a couple of questions have been coming in, but as I said, I think it will probably might be more specific or for us to just determine which line to maybe refer them to. I'll just quickly mention this last one because it might just be as simple as saying which number they can call. So it said, what assets jointly owned by a victim survivor be taken into account when assessing eligibility, i.e. the victim may jointly own a home, but the perpetrator is only partly living there. So I know that we're not grants, but just what may be the best way to refer a client in that situation.
Always apply, because yes, there is a means test, and it certainly does take assets into account, but generally speaking, it's only the part of that asset that would be attributable to the applicant. So, you know, if it's a jointly held property, only half of that would be taken into account in assessing that person's eligibility.
Can I add to that too? So there's things like motor vehicles. One of the questions on an application is, how much is your motor vehicle worth? It's not what you paid for it, it's what it's worth. And you can use, I think the application form actually states that you can look in that red book, yeah, so to determine that.
That's a good point.
There's also, you know, money in the bank. There's been instances where someone may have sold a car, so they do have a chunk of money sitting in the bank, but they need to repurchase a car. So we can actually take that into consideration as well. And in relation to the property, if it's say a parenting and property matter, then there's other. So if you're talking about, we're going to look at what the property pool is. So essentially that may not be taken into account as an asset, depending on whether it's, you know, it can be a children and parenting matter, and, you know, so there's lots of, so when you say just apply anyway, absolutely, because there are, it's not all black and white, there are grey areas, and, you know, there may be situations where, you know, a client may jointly own a home, but they have no access to that home or something like that as well. So they're not, you know, they're not receiving any rent or anything like that, or they're not benefiting from having that as an asset. So as long as that, if there are situations that are a little bit unusual, always apply, but explain those situations straight up, because all that will happen is that either, if you don't explain what the situation is, either the application will actually be refused due to, and it will state on your letter, due to this, this and this. But if you can be upfront at the beginning, it kind of avoids that delay as well. You know, it may be that the grants officer who is processing that application may just be able to either send an email or make a phone call to confirm what the situation is. So there's certainly lots of, and more than what I've just mentioned, but there's certainly lots of, you know, grey area.
Because you are required to provide bank statements, and if there's a big chunk of money that, say, was, for example, gifted by a parent to pay rent for that month, so it's there, but it's not going to be there in 3 days' time, provide a written explanation of that transaction so that the grants officer can see that at a glance. Oh, well, that's what that is. And
similarly, if you provide one bank statement and we can see on that bank statement that there are transfers going to other accounts that you may have to save and avoid delays, we need all of the account statements, not just your main one. So you may have a savings account, or you may have a spendings account, as well as whatever your main everyday account is. We will ask you for that. We will say to you, we can see that there's, you know, regular transfers going to this account. Please provide copies of those statements as well.
If you're running your own business,
correct,
that's always fraught for grants officers, because it may be that, you know, the records show you're earning nothing. You need to be able to explain that to a grants officer as to how you're surviving, how you're meeting your expenses, provide your profit and loss statements so that these questions are answered and delays are avoided.
Thank you so much for that. So we might wrap up with the questions, and we'll endeavour to get to everything If you do have anything else you want to ask, please just email webinars@legalaid.qld.gov.au. You can also get, download and order free publications on the website. And we're still finalising the details for our next webinar. So when that is available, we'll be sending out a reminder. You can also access all of our webinars on our Legal Aid YouTube channel for free. This one should be available next week, so we'll send out a link to that when it's ready. And of course, just follow us on Facebook, LinkedIn, Instagram, and X, just for all upcoming topics, dates, and other useful legal information. I wanted to thank you all for joining us today. Thank you to our interpreters and a big thank you to our presenters. It was great. Thank you so much.
Thanks.